I don't even know how to react to this costume. Dude, you're right, but don't do it. Do they have a defense for punching you in the face for wearing that costume? Yes. Burning buildings, Diddy costumes, and broken ankles. What do they all have in common? They're all part of what I'm gonna discuss today. As a trial lawyer, I'm Mark Breyer, and we're gonna go over what can happen, what can go wrong, and what lawsuits might be filed when it comes to Halloween.
Flames tearing through both stories of this suburban house outside Greenville. But the message from the home's owners, please stop calling 911.
It's all lighting. Each window has its own little setup.
It's just the latest over-the-top Halloween decoration from Sam Lee and his fiancée Amanda Pedden. All smoke and lighting. The display, they say, is a hit with most neighbors.
We do have a 1% that, don't like it, and that's understandable. They're entitled to their opinion, but we do it for the community.
If this is too far, what's not too far? What's the line? And who's to say what that is?
The couple gave the fire department a heads up about their elaborate display, but that hasn't stopped the calls from coming in.
Does this in any way take away from resources in a smaller fire department?
No. Granted, we're lucky we're a block and a half from where the house is at our main station. So regardless, if somebody calls, we're going to go.
All right, so you got a bunch of stuff going on here. So let's talk about it. First of all, let's talk about the neighbor side. Is your neighbor allowed to do whatever they want for Halloween? The answer is no. So there are both laws and there are CC&Rs. So let's get into this a little bit. You cannot do anything offensive, scary that you want. That was a really good question the homeowner asked. Where's the line drawn? The line is a factual question, but there is a limit, right? You can draw so much traffic in, you might have a problem. The bigger problem in the law is your CC&Rs. If you have a homeowners association, you have agreed to abide by the CC&Rs. Now I'm going to tell you something. If you have a homeowners association, you probably have frustration with your homeowners association, who probably has people on the board that think it is their job in life to make your life miserable because they love the power. Let's put that over to the side. The point is, you did agree when you bought the house to the covenants and restrictions that are part of it. So there may be things about what you can do with the house. Now, the interesting thing about that house is, I looked like that house was on fire. One, not really sure that that's a Halloween thing, house on fire. It looks like the local fire department doesn't have a problem. Most of the neighbors don't have a problem. And assuming they only keep it up for a month of the year, you're probably not gonna go in there. What are you gonna do? That's another issue here. What are you gonna do if your neighbor has the most ridiculous setup of Halloween ever? You're gonna file a lawsuit? That's great. That lawsuit may take you a year or two and tens of thousands of dollars to push through the system. By then the neighbor's moved or you've moved. It's really a tough situation because the law is not built for speed.
A Nebraska woman is suing Kansas City's haunted house, The Beast, after allegedly breaking both ankles during a stunt called the Beast Jump. Leslie Blake claims she followed staff instructions to jump from a second-story window onto an inflatable air pad, which she says was underinflated, poorly positioned, and lacked proper supervision or warnings. The lawsuit alleges Full Moon Productions, which operates the attraction, knew or should have known about the risks, citing prior injuries linked to the same jump. Blake accuses the company of negligence and recklessness, seeking over $75,000 in damages, plus court costs and interest, Fox 4 Kansas City has reported. Full Moon Productions promotes its attractions as safe, with fire marshals, security, and monitoring technology, and requires visitors to sign waivers before entry.
Ooh, so much there. First of all, let's talk about the waiver. Every state has different laws on waivers. In some states, when you sign a waiver that says, I give up the right to sue you, oh, you give up the right to sue, no matter how negligent. Let's use an example. In some states, even if they knew that this was a totally underinflated piece to save you and knew you might get hurt, as long as it wasn't intentional, it was truly negligent, they're off the hook. So before you go sign that waiver, understand, depending on the state you're in, you may truly be giving up rights no matter how absurdly negligent they may be. In some states, it's to the other extreme. It's not even worth the paper it's printed on. It's got very little value. And then there's the middle, the states where you can show the jury, hey, you signed this, and so to some degree we're protected, but the jury can make a decision in terms of the degree of negligence. It varies widely across the country. So that's number one. Now here's what I get with these cases. I know that you're sitting there right now and you have pretty strong opinions. You're either like, whoa, a bunch of people got hurt here and they're they're trying to get out of it by, hey, you signed this waiver, that's ridiculous. Or you're like, yo, you jumped out of a 2-story window, you signed something, you knew it was risky. If you get hurt, that's on you, that's not on them. There's gonna be strong opinions on this, which means the jury who hears this case, strong conflicting opinions. If it's true that they absolutely knew or should have known that there was risk that was avoidable, and that's the key, right? If the thing she landed on was properly inflated, it was properly supervised, this was a fluke incident, it's a much harder case. Hey, we have 6,000 people a day jump off this for an entire month, and every third year someone breaks their ankles. It's a much harder case. On this day, they didn't have the safety equipment. When you jump in a situation like that, you're kind of counting on them to have done their job too. Here's where I always go, and this is where most lawyers on the internet don't go because they're not actually trial lawyers. The answer to this question depends on facts we don't have. How many people were hurt? How were they hurt? What are the details of this incident here and what this particular place knew? And what is the law in that state for the power of a waiver? And until you know that, you can't do the thing lawyers love to do, which is go, they're responsible. Oh, she assumed the risk. We don't have enough details from that to know it. We know this in Kansas City, and most people think of Kansas City, Missouri, but there's also Kansas City, Kansas. Let's assume this happened in Missouri. What are the laws of waivers in Missouri? That's the question that's going to matter. Now, little piece that I mentioned earlier, this woman gets to go, well, I'm not from Missouri. I'm from Nebraska, and here, no. The incident where it happened is going to govern the law of those waivers. Okay. I don't even know how to react to this costume. However, let's talk about a couple things. Number one, you wear a Diddy costume and someone goes, with everything he did to women, that's not funny, and they punch you in the face. Do they have a defense for punching you in the face for wearing that costume? Yes, but not a good defense. They're gonna go to jail and you're gonna be able to sue them, although they may not be totally wrong. What about the fact that's Diddy's face? What about name, image, and likeness? Dracula can't sue me because Dracula's not alive to sue me. Frankenstein can't come after me. How are we allowed to use all these names and faces without their permission? Generally speaking, you can't. If I want to design and sell a Mickey Mouse costume, I need to give Disney their share of it. So either Diddy has the right to sue here for using his name, image, and likeness. If it's actually a picture of Diddy, the baby oil part, that's a little separate, but you are using his face. Maybe they actually went and got Diddy's agreement to this. Probably not. Or they're like, we dare you to sue us, Diddy, with everything you have going on. Now you can dress up like someone. They can't sue you for dressing up like them because it's a parody. Oh, they're calling it the Diddler costume to try to say it's a parody. That's really, really interesting. And I will admit, as a personal injury lawyer, I do not know if they could use the parody exception. This is not called P. Diddy. This is called Diddler. Of course, none of that matters because Spirit is not having the Diddler costume up because this was a super creative creator who threw out the Diddler costume idea. But to whomever did it, you're onto something. Here's a question that fits right in what I do. Personal injury law, let's get to it. Halloween trick-or-treating liability. You gonna get sued for those little monsters that try to show up at your door? Here's the question from Reddit. Honestly, just curious. If a trick-or-treater were to fall and break a limb on my property, could I be sued? I would assume it could be considered I've invited them onto my property by giving out candy. My walkways and front stoop are safe 20 plus years ago. At a former home, a neighbor's daughter tripped on a metal bar in our yard and scraped up her leg. We had no idea it was there despite having mowed the lawn many times over. Our current yard has some roots from huge trees that are a tripping hazard. Just a morning coffee thought. Personally, I'd never have sued if my kid tripped and got hurt on Halloween, but my kids are now young adults and times have changed. 90% of my trick-or-treaters are not neighbors. We are a destination neighborhood, LOL. Thanks all. Woo, good questions. All right, a lot to this. Personal injury law varies dramatically from state to state in some areas and is similar in others. When it comes to this, it's called a premise liability case. What responsibility do I have if someone's hurt on my property? It varies dramatically. The biggest misunderstanding that people have about when someone's hurt on their property is there's this general understanding out there that if someone gets hurt on your property, you're responsible. And that is not true. And it is one of the biggest misunderstandings in the law. They have to prove their case and you have to have done something that was negligent. Many states follow a really formal standard of someone who is an invitee, a licensee, or a trespasser. I'll get into those in a minute. Many states have abandoned that and they've just gone to a negligence standard. Basically, did you act as a reasonable person would when people were going to come on your property? That's a lot easier, right? But many states still hold on to this other standard, so let's talk about that. An invitee is a business. So you show up at Arby's because, they have the meats and you want to get something at the Arby's and they have a dangerous thing on their property they knew or should have known about, and they don't warn you, and it's not so open and obvious that you can't miss it, and you get hurt. When you sue Arby's, you have a stronger case. Now, let's say you're just in the neighborhood and your kid's trick-or-treating. You are a licensee. You're allowed onto the property. Why? Because it's Halloween. So someone with a bowl of candy and lights on, they're saying, come onto my property. I'm not selling you anything, so you're not an invitee. I don't have to give you this heightened standard, but I do have to be reasonable in terms of what happens on the property, because I know little kids are coming on. I know those kids have masks. If I have roots sticking out, kids are gonna come running up. That's something I have to be aware of. Trespassers. I don't know about you, but I get stuff forwarded to me sometimes of these massive lawsuits when someone like breaks into a house and they get hurt breaking in and then they sue for millions of dollars. That never happened. I know you think it happened because you've gotten emails or you've seen it on Reddit and all these crazy lawsuits. They never happen. If you track them down, almost never. Never's a big word. So we'll go with almost never does a trespasser win a lawsuit. You have to basically have something set up to shoot the trespasser when you shouldn't for stealing your candy. Trespassers lose under the law virtually every single time. So when you read these ridiculous things about someone trespassing and getting hurt and suing for millions and winning, now maybe they sued and they lost. So if you're getting sued now, let's say this little Darth Vader comes onto your property, fails to use the force, and falls and gets hurt, you are going to want to argue Darth Vader is a trespasser. I don't know Darth Vader. I don't know Darth Vader's parents. I've seen Darth Vader's mom in the movies. That is a trespasser. Here's the problem. If you have signs and signals that you're participating in Halloween, Darth Vader is probably not a trespasser in most states. How could you fix it? Don't do Halloween. No signs or signals to suggest that you're participating in Halloween, or put lighting on the area, put some yellow tape, do something to gain awareness for the people who come running to say, hey, here's an issue. You didn't put out anything. You said no trick-or-treating. Your lights were off. A kid comes up and gets hurt. You have an argument, pretty strong argument probably, that this is a trespasser. But there's always a lot of factors involved in that.
Chainsaw, and it's loud, and he's coming at me, and then I feel something on my shoulder.
What did you feel?
There are hands, like hairy hands, huge werewolf character touching me, and I immediately freak out and run.
And so you start running, then what happens?
As soon as I start running, I hit a brick wall. Immediate shock and a lot of pain, a lot of blood.
This broken nose is due to her own negligence. We've had 500,000 people come through, over 500,000. Okay. Not a single person has been injured. Catchphrase is in there, prepare to be scared. The ticket clearly has stated on it, prepare to be scared.
And I was totally prepared to be scared. I was not prepared to be in the hospital. He grabbed me.
I looked at it closely, the warning in the fine print. Warning, characters will not touch you. I find in your favor for $48,000.
Whoa, I didn't see it going there. All right, let's go through this. It's an injury lawsuit. This is my area. Let's have some fun. All right, first of all, she is suing, and her basic lawsuit is negligence. For what we know, she did not sign a waiver. It's a little unusual. Like if you're selling tickets to a haunted house, the first thing you ought to have people do is sign a waiver. In that waiver, you can do what most people do, which is a whole bunch of legalese they don't understand. That's good. Even better is, before you get to all that legalese they don't understand, have some big bullet points that talk about the risks of everything going on. What you just saw the judge do, though, is not the law. It's a factual determination. So let's go through that. Legally, here's what she has to prove: that they were negligent in causing her injury. Two things the judge did that are surprising to me. Number one, he seemed to give no comparative fault. They touched you, so they're not just at fault, they're 100% at fault. Wait, what? I was in a haunted house, went running when I couldn't see anything, ran into a brick wall, and it's not my fault at all. If this was a jury trial, the judge would read the law about negligence, and the jury would decide, was there any negligence? And if there was, who bears what percentage? This judge, when he said they touched you and they agreed not to, and they're totally at fault for $48,000, made two factual determinations. Now, judge can do that, but understand he's really playing role of judge and jury there, as happens in, it's called bench trials. What you're dealing with here is that legally, he found them negligent because they touched her. This is one of those things where I'm gonna share my opinion, but I wanna put it in some context. When I share my opinion isn't better than the judge's. The judge is just another person who's making a factual determination. Here's how I see it. One, that's true. It said they weren't going to touch you. And no one should be putting their hands on a woman when they've said they're not going to in any context if they did. Now, I don't know if they agree that they did that, if she just thought they did that. I don't know. But let's assume for the purpose of this situation that no one disagreed and a werewolf touched her. All right, fine. So she didn't get hurt by the touch. She got hurt from her reaction to the touch. Could you argue that, you know what, if you say I'm not going to be touched, and then in the middle of me freaking out, I am touched, that this is something I didn't expect, you can argue it. I don't know if I'm buying it, to be honest. She was freaked out, period. Enough to go running where she couldn't see. Running, not even like kind of moving fast, hands up, but just running where she couldn't see. But if they have some responsibility, and I have a little trouble with that personally, at a minimum, a significant percentage of the fault is on her as well, because we assume she told the truth. Let's assume he told the truth. Thousands and thousands and thousands and thousands of people come through there without ending up in the hospital. You end up in the hospital and it's totally their fault.
58-year-old Stephen Markham is in hot water over his Halloween decorations. On Saturday, police received complaints about the display that appeared to show fake body bags hanging in his front yard. Police say the decorations depicted the bodies of local officials. They say one fake hanging body bag was labeled District Judge with a rope around the neck. 4 other bags were labeled Mayor, SIS, CA, and Zoning Manager. Markham was arrested and charged.
I actually already recused from this case yesterday.
In court, he was supposed to be arraigned on charges of intimidating a participant in the legal process and third-degree terroristic threatening. But as you just heard, the district judge recused himself from the case, postponing Markham's arraignment.
This day and time, we don't know what people's going to do.
Powell County Judge Executive Eddie Barnes has known Markham for years and says while he has never had any problems with him, he believes incidents like this have to be taken seriously. LEX 18 has learned Markham has been in an ongoing dispute with the city of Stanton over zoning ordinance violations for failing to hook up legal water, sewer, and electrical service, creating what the city calls potential fire hazards, sanitation, and health risks. At a September 30th court hearing, a judge found Markham in violation of a city ordinance, fined him $250, and the judge gave him 30 days to comply. Not long after, police say Markham put up these threatening Halloween decorations.
You know, if you're going to express yourself, don't do it in a way that could be harmful to others.
This is where we all need a friend, not the friend to sit there and just listen, but a friend to go, dude, you're right, but don't do it. Do you know how frustrating it probably was for this guy? He hasn't hooked up his water, electricity, whatever they want. They're giving him a hard time. He just wants to be left alone. The powers that be will not leave him alone. He's probably someone that figures he's good to go. Whatever electricity they want him to have, water they want him, he's living his life. Leave me alone. And here come these powerful entities going, you're going to do it. You're going to do it. Now we're going to fine you money. If he had an extra $250 lying around, he may have. But if he had, generally, he might have already hooked it up. He just wants to be left alone. And so he's like, you know what? This is what I'm going to do. I'm going to put up some Halloween decorations and say they were just Halloween decorations. And I'm going to threaten the very judge who could put me in jail, or because the judge properly, by the way, credit to the judge for accusing himself. It's going to go to another judge. How do you think another judge feels about you threatening a different judge? Probably not too good. How do you think another prosecutor feels about you threatening someone in the legal process? Probably not too good. Let's talk about the legalities here because there's a lot going on. He's going to have trouble because he labeled the Halloween costumes to claim they weren't intimidation of any kind. It is really important that all of us take seriously protecting the judicial process. We cannot intimidate judges. We cannot threaten judges. We cannot intimidate witnesses. We cannot threaten witnesses because it goes to the sanctity of how we get justice in this country, and it actually really matters. So I'm not that big on getting all like super serious about everything, but I almost feel this guy's pain. He may have been totally wrong, but in his mind, he was totally justified. He was getting the runaround from the government. He felt he just wanted to be left alone, maybe. It's my assumption. And he just went one step too far. And so I would encourage you to probably not have Halloween costumes that threaten anybody, even if there's no more light on. Now, one of his defenses is going to be freedom of speech, freedom of expression. Yes, but it's not going to fly. It's not going to fly for 2 reasons. Number one, who's going to be making the decision? It's going to get in front of a jury, but how the person's charged is coming from the very government that in effect he's threatening. It's the power of the government. Fortunately, we have a jury to hold tight on that. The government's overcharging, but it's a problem. And second, even speech and expression have a limit. We don't have in fact, the famous example that goes back 100 years is you can't go into a crowded theater and yell fire. When everyone goes running out and someone gets hurt, you're in trouble, criminally and civilly, because you can go, I had freedom of speech to yell fire. No, you didn't, because you created an unnecessary risk. If you could just say anything you wanted, then there would be no actionable claims off what you say. But things you say, expression through Halloween, it is not unlimited. And actually naming people in the judicial system like that, body bags, you're going to have a problem in most places.
And Hershey beating a lawsuit this week claiming its Reese's Halloween candy isn't spooky enough. So this suit alleged the company misled consumers who were disappointed the Halloween-themed Reese's they bought lacked the decorations shown on the labels. The judge ruling the plaintiffs didn't prove they suffered any economic harm, and the subjective belief they overpaid for the candy, well, it didn't support their claims. The proposed class action suit by 2 Florida residents was seeking at least $5 million in damages, Savannah.
So let's talk about class action lawsuits, everybody. Here's the issue, because it's important to understand, because of how stupid they often sound if you don't understand the idea behind a class action. Let's say you own a huge company. We'll use Reese's. And let's say you purposely cheat everybody out of 3 cents with every single product you sell. In my hypothetical, Reese's purposely scams the public because it makes them an extra 3 cents profit every time they sell you something. You figure it out. What you gonna do about it? I'm gonna sue them. No, you're not. You're not gonna sue them for 2 reasons. 1, because you don't care that much about the 3 cents that you lost. And 2, even if you cared, it's going to cost you tens of thousands of dollars at a minimum to push that case through. Maybe $100,000 or more by the time you're the company that big and the defenses they'll put up. Idea behind a class action lawsuit is to not allow powerful parties to get away with that kind of stuff. To get away with the stuff that's worth such a little thing that no one could ever sue you for it, but you're making millions. And if we don't give that power, if we take away the power of the class action, what prevents every single company from screwing every single customer and client intentionally out of 1% or 2% on everything? Is that good business? Is that what we want in this country? We want people to be able to get away with taking advantage of every single consumer for a tiny little amount that adds up to them over the course of time, but there's nothing you can do about it? No, we don't want that. So we create class action lawsuits. If the government's not going to jump in, and the government's got a lot going on and often does not jump in, maybe the Reese's lobby is powerful. We want private causes of action to hold companies or big parties accountable for this kind of nonsense that I just created. Almost none of which has anything to do with this lawsuit, because this lawsuit sounds relatively stupid. However, saying that the candy isn't spooky enough, it's like anything else. I don't think the flavor is what I thought. I don't think the design is what I thought. You just don't buy it again. You go and do a review of it. You tell your friends. A lot of times people hear about these stupid lawsuits. Like right now, when you heard about this lawsuit, did you go, our system's broken? This is ridiculous. People suing over what the candy looks like. No, the system's not broken, y'all. This is what the system's designed to do. 1, prevent powerful companies from taking advantage of people. And 2, protect powerful companies that didn't take advantage of people. Someone claimed they did and filed a lawsuit. Good. Which was dismissed because it was nonsense. Even better. This is an example of things working. Someone made an allegation. The allegation was found to be baseless. The case is gone. Everything went right in this situation, even if your gut reaction to it was, what the heck is going on here, and our system's broke. Stage content. Oh no. All right, let me just stop here. Hell no. That is the legal response to this. So if anyone out there, oh, that'd be funny. It doesn't matter what the truth is. People have a right to react based upon a reasonable belief of the truth. So if you pretend to kill someone and someone jumps up and shoots you in the head, your survivors are going to lose the lawsuit because you were pretending that you were attacking someone, but a reasonable person would believe that that's what you were doing. You come out in clown outfits with weapons coming at someone and you're like, yeah, but it's just a joke. They don't have a right to do anything. Yeah, they do. And not just in stand your ground states, y'all. I'm already scared and I know it's a prank. Now, by now, no one's around. Why have you not looked up? There we go. And this is where, if you're in a state with a lot of gun owners, listen, Clown Prince, this may end poorly for you. But if the other person doesn't have a weapon, now we got to watch out how they play it, even though we know this is just for show. Of course, you got a chainsaw. By the way, don't you think it's odd, even though they're just playing, they're just standing around? So I don't know about you, but some killer clowns are coming at me, and I got 2 friends with me. If none of us has a weapon, and if we choose not to run, which has the advantage of you just have to not be slower than your friends, you would think at least you'd be making a plan, not just chilling and waiting. I'm just saying, the next time they act this out, you would think they'd be yelling at the person. Who are you? Why are you coming at me? This is not a joke. You don't think they would just stay quiet and wait to see what happens? But they're doing a good job building the drama, so maybe I shouldn't be too mad at them. Almost for sure someone is going to say something. There's the run. Let's say this is real. You thought it was funny. I'm going to dress up as a killer clown. Someone falls down the stairs. Is it on me? Yeah, it's going to be on you. Because they had a reasonable belief that their life was in danger. They acted in a reasonable way. Someone running, not prepared to run down those steps may get hurt. Could there be comparative fault for how they ran down the steps? That'd be up to a jury. Who's the jury going to side with? Them. Because you were the fool who dressed up as a killer clown. Did you guys see that thing on the screen that said a couple times this is stage content? What if they didn't put that? And someone saw it and said, that's the best. Let's do that Friday. Yo, let's go do that. Can they sue you because you gave them the idea? They can sue you, but they are probably not going to be successful because the fact that you did something stupid did not require them to do something stupid. There's probably not much of a legal duty on your part to try to stop other people from being idiots. So why do we see the disclaimers all the time? You know, this is man on the side. If NBC or ABC or Fox posts this, CBS, whatever, or Netflix or whatever, and they don't say it's stage content, they probably have a different situation because their audience is massive. And if they poke fun at how cool this is to have people going up dressing up as killer clowns and watching people freak out, they probably do have some expectation that some people are going to follow that. Is it a strong lawsuit? Maybe not, but it's enough of one that they want to be very, very certain. You know, they want to eliminate the risk that people think they can go out and do this, even though I still would say a large percentage of the fault will likely still stand, depending on the facts and what we know and what they know, with the idiot who decided to replicate something that's stupid. Funny, but stupid. Thank you for watching. Please don't forget to like, comment, so we know what you want a real trial lawyer to respond to. And by the way, look there. YouTube thinks you're going to love that video.